Welcome to Straight Talk for Entrepreneurs, where we reveal what it really takes to build a successful business. Whether you are starting with an idea or growing your business, this is the show for you. My guests and I will show you how to build a strong mindset, a powerful body, a profitable business. Hi, I'm Brandon C. White, and this is Build a Business Success Secrets. This is unstructured, and I do that on purpose because we're already recording. So there you go. But both of you are experts in, well, you're an expert in law, but in startups and in founder conflict for the most part. Is that right?
Mm-hmm.
Hopefully resolving it more than the conflict itself.
Well, we're going to talk about that today, David, because you're talking to an entrepreneur who has not always been able to resolve that conflict. So I'm interested to hear from both of your perspective some of the common things and how you actually resolve these conflicts. And could you, or I don't know how we want to go around now have a round table. I've never done two people in 121 podcasts so far. Maybe, I don't know, more when somebody listens to this.
Feel special.
Well, when you both contacted me, I was like, are we going to do both people? I really haven't done that yet, but you know what? Two lawyers, let's make it happen.
Really 1.5.
1.5?
We're very much on the same plane.
We finish each other's sentences. Yeah.
Oh, well, that's interesting. But you haven't, both of you went to different law schools. David, you went to NYU, and Mital, you went to Georgetown, right?
That's right.
Yeah. We never met before.
We were in New York at the larger firms at the same time, but we never we didn't meet until Grellas Shah.
And how long have you been there at Grellas Shah?
10 years.
Almost 10 years, yeah.
Oh, that's a long time.
Mm-hmm.
Well, at least you came over to the right coast. I'm saying that as an East Coaster originally myself. So
are you here on the West Coast?
I'm right here in Half Moon Bay.
Oh, nice.
He's very, very, very coast.
Yeah, I'm as coastal. I don't know. You can look out the ocean. We should have done I'm almost done my studio in my backyard, and you both could have come over and then we could have walked to the ocean, but it's not quite ready yet.
No.
That would be great.
That would be great.
How does that work with the sound though?
Yeah.
Does that interfere?
Wait, what's that? The ocean?
Yeah.
Being outside.
Or just being outside generally.
I was wondering that with Megan and Harry's interview with Oprah. Like, how do they do this? They're outside.
Oh, very, very expensive mics.
Mm.
But my studio isn't outside. It's actually inside, but I have a whole door that opens into the yard. So it's a separate building that I'm building, believe it or not. And I think it maybe happened because of COVID. I don't know. But I started to think, well, if we're going to do this podcast thing again, we should probably do it right. So
I agree.
So let's talk about, because I know our listeners get tired of me rambling sometimes, but we're talking about startups and conflicts that happen in startups. Could you both, whoever wants to go first or whoever finished each other's sentence, is what are some of the most common conflicts that come up and that you see or that you've seen recently, maybe even with COVID? Maybe COVID has increased those conflicts because everybody's under tension and money's getting tight in some businesses and things are happening.
I can give you the one-word answer, and then we'll give you the more elaborate answer. It's equity, usually. Usually it's around the cap table and equity, and it's about what someone's getting, how much someone's getting, and someone's not getting enough. Obviously, when in startups, when you have founders putting in 80, 90 hours a week and giving it their all, there's going to be, the feelings are going to run high, but it's usually around compensation and equity. Sometimes it's about the direction of the company, obviously. One person wants it to go another way. One person really wants to push the VC route and try to get funding, and there's disagreements there. But I would say the majority of them are around compensation and equity. And I think I was saying this to David earlier, when it's kind of like in a marriage, when both husband and wife, or both spouses think they're putting in 60% of the work and the other one's putting in 40. I'm sure I think that. I'm sure think that too. But it's the same in a startup where you're putting in so many hours and you're putting in so much work, and you don't necessarily. It's hard to see that the other person's doing the same, and so sometimes there's hard feelings about what the initial breakdown of the equity was at the outset, and what the reality is in terms of how the work's being done. 3 years later, there's not always. There's usually a mismatch there.
What do you think, David?
That is correct. I need to add the slightly more cynical take on that. All of that is true, and then you have to add in the creeping in of greed in some cases. It just one can't escape that. It is a part of this world, the startup world, where there can be dollar signs, and I have seen my fair share of situations where founder A decides some months in that it would be better for them to, have a larger percentage of the company by getting rid of founder B, and they've gotten what they feel like they need out of founder B, and so they push founder B out. And it could be about more noble reasons like direction of the company or good faith differences about who's putting in the work, but unfortunately, sometimes it literally is just greed. And I hate it when that happens, but it does.
Yes, we talk about how we hate the concept of dead weight on the cap table. I don't know if you're familiar with that term, Brandon.
Oh, I'm not only familiar with it. I was a venture capitalist and I've had 2 exits so far, and I've probably tried 20 times, maybe more, depending on what you call projects. But the dead weight it's really painful.
You mean from the investor side or from the?
No, from people who, when people come early on, and they do. I'm not saying that they don't contribute. They contribute at that moment, and I want to talk to you both about this on how to mitigate this, because for some reason, after 2 decades being an entrepreneur and a venture capitalist and an angel investor, I still sometimes get it wrong, because I think human nature is that you don't want to address that conflict when you're starting a company early on, because it's early. But talking about dead weight is just that you have this person who, I guess at the moment I'm saying the team agreed, and a lot of the time the lawyers aren't involved in the early days. They
Not in terms of the breakdown. Yeah. That's decided internally.
They should be. I'm saying they should be, but as an entrepreneur also, you're trying to be cheap, and because you're usually broke, or even if you're not broke and you're doing it again, you're trying to cut down on expenses. But I think it becomes painful. And then 2 years later, you look back and you say, who am I working for?
Right.
But then there's also the other side of it, right? What was the point of that 4-year vesting schedule? Right. If after having put in 4 or 5 years, and then the company or the VCs deciding that they're not adding much value, and now all of a sudden they're dead weight, what was the point of working for 4 years and having that vesting schedule if it's a forever vesting schedule?
Well, let's talk about that, because I don't think I think in technology companies, that is a generally known thing that you should do. But I would suggest that in the broader entrepreneur, founder, startup world, people don't understand what you just described. So could you talk about what you just meant by vesting?
Oh, sure. Vesting schedule is really just a founder's right to keep their equity. When, let's say David and I are starting a company, we each get half of the company. But if I were to leave before I'm quote unquote fully vested, then the company would have a right to take back essentially half of my shares if I left, halfway through my vesting schedule. And so you own the shares outright when you buy the shares fully, but the company has a right to repurchase those shares if you stop providing services. And that right lapses over a predetermined schedule called the vesting schedule. I hope that gave a brief overview of what vesting is.
It helps. What about and I think that's what happens sometimes. The other way to do it is that the person doesn't own that stock, right? It basically VOS as a stock option.
With a stock option, it would work the way you just said, that you wouldn't hold the stock option until each vesting point. So if it vested monthly over 4 years, each month you would get 1/48th of the total amount of options. For tax reasons, that doesn't work with stock. You do it essentially the way Mital explained, but with options, it works.
And typically founders would get stock. And once you've raised VC funding and you're hiring employees, the employees after that would get options.
What do you mean by, you slipped it in there, David, because it's not tax, I guess you don't have a tax advantage by doing it. And why is that?
Tax, essentially tax efficiency. So if you take, let's say you tried to treat stock the way you were talking about treating options, where, again, let's just pretend it was vesting monthly over a 4-year period, so 1/48th per month. And let's say what you tried to do was say, okay, you would actually own 1/48th more stock every month. So you start out with 0, and at the end of month 1, you have 1/48th of stock, et cetera. 2/48th at the end of the second month. That would mean that you're literally being granted that stock each month. And when you're granted that stock, at the moment of the grant of the stock, you either have to pay the fair market value of the stock you're being granted, or you get taxed on that fair market value. And so on day 1, that's fine. You're a founder, the company's worth nothing. But let's say you're 2 years in now, and you're still vesting. If in month 25, the shares are worth, say, $1 a share, and you're vesting in 1,000 of them, suddenly you either have to pay $1,000 that month or get taxed in $1,000 that month. To avoid that, vesting for shares is treated literally the opposite way. You get all the shares on day 1 when they're worth nothing. And the company just has a lapsing over time right to take back the shares at your initial cost of essentially nothing. So that's why, from a tax perspective, with shares, it's really more of a reverse vesting than vesting. But the idea is completely the same. From the perspective of the founder or employee or whatever they are, it ends up working the same. Over the course of the vesting period, you gain a vested right in the shares or option, a right that you can hold on to. The question then becomes, with dead weight on the cap table, is what is that vested right if the intention in the background is for it to essentially be renegotiated at the end, which is something we can talk about.
So before we go there, a question on that. The company, at the time that it grants that stock, has the right to buy it back at the same price, which winds up being 0.0001 cent or a par value.
Sure.
And there's no consequence to the company, even if you're 2 years in, the person leaves, the company wants to buy it back, the stock is on paper because it got 2 rounds of funding worth $10 a share, let's say. The company still, because of that agreement, gets to buy it back from that co-founder or early person at that agreed upon 0.0001 price.
Yep, that's right.
And in your experience, does that ever cause significant heartburn for that co-founder who's seen 2 rounds of funding and leaves or gets kicked out, or however that mechanism works, and then says, but I'm leaving $10 million on the table, and then it turns into a lawsuit?
Not typically, because most founders understand that that's what vesting means. Having unvested stock means you essentially don't have a right to it and lose it. So what you're describing is usually not a problem. That's generally accepted.
Okay, well, that's good to know. And for all our listeners listening out there, this is a really important thing to understand when you are starting a company, because if you get this wrong, you are now going to wind up in some crazy negotiation about what everyone contributed, and it becomes emotional.
And file that 83B if you're doing it.
Yeah, so can you threw that in there, but that's a really, really important part here. So could you explain that?
Oh, sure. You really want to get technical, huh?
Well, I want people to know, because if I want you to describe what it is, please. And then
Sure.
if you don't file it, can you still recover when that happens, or how does that work?
Usually not. Usually not. The IRS is not very forgiving of that hard 30-day deadline. So I can give you a brief overview of 83B. But in order to understand 83B, I think you have to understand the Section 83A of the IRS code. So Section 83A essentially says that if you're getting property for services provided, you have to pay tax on that property. And you have to pay tax on that property when you fully have it. So for example, if I was providing, Brandon, legal services for you and you gave me a car, I would have to declare that car as income, and I'd have to pay tax on it at the end of the year. Now, if I'm providing services for David's new startup and he's giving me stock, that's property, and I have to pay tax on the fair market value of that property at the time I'm getting it. But at investing, right, we have the stock isn't fully vested until 1/48 at each month over a 4-year period. That essentially means that the company can take it back and it's not fully mine. So why am I paying tax on something that I don't necessarily already have? And so the IRS says that you're not going to be paying tax on that property until the risk of forfeiture has lapsed on that property. Now, what 83B does, it's a voluntary election. And by filing it, the founder is essentially saying, look, I get it. I might not get that car fully, or I might not get that stock, but I'm going to go ahead and declare the entire car or all of the stock as my income for services provided on day one, and I'm going to voluntarily pay tax on it. And the reason why founders do that is because that's 1/48 of that stock, 2 years from now could be $10 a share, at which point I don't want to pay tax every month on, at that price, $10 a share. Right now, the stock that I'm getting, usually at founders at incorporation, they're going to get their stock at 0.0001 cents a share. Right now, I'll pay tax on $10. I'll pay tax on, 0.0001 cents a share stock, even if that stock might be taken back from me, as you said, 2 years from now. That's a risk I'm willing to take. I'll go ahead and make that 83B election and tell the IRS that I got this stock for services provided, and I'm going to pay income tax on this stock for the value of that the stock is worth right now. Now, the beauty of 83B is that the election has to be made within 30 days of you actually getting that property. So once you sign that stock purchase agreement, when you're joining the company, you're signing your invention assignment agreement, your offer letter, your stock agreement, make sure you file that 83B within 30 days and make sure you have proof of that filing. In my experience, it's not really the IRS that comes knocking, right, and audits you 2 years from now or 7 years from now or whatever. It's usually a problem in diligence when the company is being acquired. But yeah, it's important to, if you're getting stock options, then you don't necessarily have an 83B filing unless you're early exercising. But if you're getting your restricted stock at incorporation as a founder, it's important to make that 83B filing in time.
And what happens, and just to be very specific, that means that when a person who generally incorporates in Delaware files that incorporation and gets whatever its common stock, if if you don't file that within 30 days, you've lost completely that opportunity?
Yes.
Yes, it essentially means you have to treat it as income and declare income tax, pay income tax on the property that you're getting at each vesting point.
Which translated for everybody listening means that you are getting taxed at ordinary income, because that technically is a short-term gain, or is it just because it's income in general?
It's ordinary income no matter what. It's just that you're going to have ordinary income tax on at each vesting point during the vesting schedule. And it could be presumably at a time in the future when the stock is worth a lot more.
Let me ask another question. If someone isn't vesting, so let's say the three of us create a company, legaladvice.com or whatever we do, and we all get the stock. There's no quote unquote vesting schedule on it. Is there any reason at that point to file the 83B, right?
Right. No. If there's no vesting schedule, then there's no 83B requirement.
So this is all around the vesting schedule.
Mm-hmm.
Right.
All right. Go ahead,
It's
David.
one step worse, because if you think about what you're having to file taxes on and pay taxes on, it's at each vesting point, the difference between the fair market value at that time. This is if you don't file an 83B. It's the difference between the fair market value at that each vesting point and the amount you paid, which means taking a position at every vesting point about what the stock at that point is worth. So it's a headache in addition to being more taxed.
And you could, if I understand this correctly, also overpay, because the stock could fall and you would have paid tax on a higher price that 6 months in the future it dropped.
Yeah.
Yeah, entirely possible.
So for everybody listening, this is only when you have a vesting schedule for founders, when you are granting the stock when they join. So someone, just let me make sure, David and Mital, I have this right, that you could have a founder who founds a company and does this incorporation. They own all the stock at that point. There's no vesting schedule for them. They don't need the 83B election because there's no vesting schedule. 3 years later, they bring someone on as a partner. They decide to give 30% of the company to that person. At that point, when that person gets that document that says you're being given 30% that's going to vest over 4 years, I guess, in general, at that point, that person has 30 days to file that 83B election.
Right.
Wow, this can get really complicated. This would be a good reason to hire a lawyer in the beginning if you're going to have people who vest, right?
Yeah. Generally, you want to make sure you're doing that part right. It gets expensive afterwards.
What happens if you grant the person stock, they vest that stock, they get through their vesting schedule, they quit at that point, they stay with the company still 15 years later is still going, and they're still sitting on the cap table. They haven't contributed anything. And you go for a sale, and I've seen this happen where founders will, or the current management team will say, you know what, like this person's been sitting on the cap table for 10 years. They worked here 4, they haven't done a single thing. They own, double digits of stock. We want to renegotiate that. Does that happen? And generally, how does that go?
And are you talking at one point? I think you mentioned there being a potential sale of the company. Are you talking about in the context of an actual sale, or kind of preceding looking at selling the company?
Proceeding looking at the company, they say, founders say, hey, look, it's time to sell this thing. Maybe they've gotten a soft inquiry, or an inbound and they've, haven't officially signed anything at that moment. And they're starting to go back through their binder. Hint, hint for anybody out there that should have a corporate binder with all their legal documents ready for diligence. And they like, oh my God, John Smith's been sitting on this cap table. We've been busting our butt and this person's going to benefit. We're going to go. We don't think that they should have that. Are there any mechanisms at that point that you can either reduce their stock, add another class of stock, go back to that person and say, hey, we want to buy that stock? I mean, what sort of mechanisms do people have to even, if any, at that point, to get someone off their cap table?
Not much. I mean,
not at that point.
usually in the startup world, it doesn't end up being at that point. It's usually right after the person leaves. It's rare that a company would go like 10 years and not notice that there's someone on their cap table who's long gone. They would usually do something about it before that.
I think a gremlin
I think.
got
Well,
the-
I continue. Oh wait, we lost a bit of what you were saying. That's all. I'm sorry.
Oh, I'm sorry. Bad connection.
Yeah.
Yeah. No. So what I was saying was once you leave the company, that's when the startup would try to determine how to account for that person on the cap table. They're not going to wait that long. Most companies don't wait that long. And once you're in the sales stage or pre-sale stage, it's almost already too late because no buyer is going to want to take on that kind of risk.
So what type of advice do you both have for people coming together? Because oftentimes, especially here in the Valley, but I think it happens everywhere, even with a cupcake company in Tennessee, founders get together, they have this great idea over dinner, and they start working on it. And there's never this discussion of, because the initial idea isn't, well, I think everybody wants to make money. I think they should at least, otherwise it's a hobby and it's not a tax deduction, there's never this discussion around equity. And then money starts being made. And I think, Mital, you were saying, everybody thinks that they contributed 60% to the company. So if you wind up in that situation, because the advice otherwise is don't wind up in that situation, which we can talk about. But when you do wind up in that situation, and probably when both of you are involved at that point in some sort of mediation before a lawsuit happens, what advice do you have to people to sort of figure out really what that equity split should look like?
So you're talking about the situation where they kind of haven't really thought about it, or?
Yeah, they got a business. They started making cupcake. They got this magic batch that eventually becomes sprinkles times 10. They start selling all these cupcakes. They start making money. They've never talked about an equity split. And at that point, they probably haven't even incorporated. They've got to incorporate at this point. And now they got to have this discussion about equity. What sort of advice, or how do you both handle that when you're sitting in the room with these, let's take it, two people, to come to a halfway rational discussion about how you do split up the pie?
Right. I mean, it's, by the way, usually when it's gotten to that point, what's more likely to have happened is they kind of have had discussions and they both think they know exactly what they do. And that has its own hairiness, but it's a slightly different question, but it is the more common one. If they really haven't spoken about it, the first thing to do is to disabuse, and this is not the answer to the question, but you first need to disabuse them of the 50-50 notion. A lot of when you're talking about two founders in particular, they will, unless they think that they somehow have this great claim to a much larger percent of the company, they will think 50-50. 50-50 is a recipe for a disaster on many, many levels. The most kind of obvious one being you can't do anything if you disagree, and that just cannot work. And the reality is someone is going to have a majority. Somebody needs to be able to essentially break deadlocks, if it's more than two people. And if you can't be comfortable with somebody else having that power, and you can't convince the other person you should have that power, then you can't work together. It will never work. It just can't. Somebody has to be a minority shareholder. And it can be hard to kind of accept that, but somebody has to be. And you have to go into a startup understanding that, particularly if you're a minority shareholder, that you could get kicked out, you could have decisions made and imposed on you that you don't have control over, and that this might not be the vessel for your dreams to be filled, and it might not be the cash cow. You had mentioned, Brandon, towards the beginning, like, 2 successful exits, 20 others, depending on, whether you want to call it a project or a startup. And that is every particularly young founder, and this is usually an issue with young first-time founders, needs to hear words like that, because it's not just that most startups fail, it's that this is not your only chance. So there has to be a dose of, I feel like I'm being cynic today, there has to be a bit of a dose of realism that we need to kind of convey, that depending on the person, maybe I am talking to the person who's more naturally the dominant founder, but it's a harder discussion with the person who won't be. Just explaining to them that we can't create a situation where you will have everything you want and be protected in every way, because that threatens the company's viability. So that's the first thing, is we just need to get people out of the 50-50 thought process. And then we really just need to understand better what the intent, like what people have done, what people are contributing, and then it's focusing them towards a discussion between each other. Because the reason that this discussion should happen early is because it might not make sense for the people to work together. It's really bad for this discussion to happen 6 months or a year in, because too much has been devoted. It needs to happen at the beginning because it's so important, and it might just plain old might not work. So the best we can really do, where it really works, is where we're facilitating a discussion between the founders, rather than, we can't tell them what the percentages are. We don't really know. It's so fact specific. But we've seen enough of this to kind of maybe educate them enough to have the conversation. And then it's a whole different situation if they think they have the conversation.
Well, before I go there, because I want to talk about that, because that's the more common situation. It sounds like from your experience, and you get to see that all the time. Mital, do you have anything to add on that?
Yeah, I would say also just be realistic about, who's more necessary going forward. In your example with the cupcakes, right? It's whose recipes were they to start with, but now that we have the recipes, then that part's done. Who's going to be the one to carry this forward and turn it into, multi-location franchise national corporation? Like there might have been an understanding at the beginning, and that understanding is different now, but the reality is who's actually going to be taking this forward. So those are tough conversations, but you kind of have to accept that maybe you're not the one who's going to take this to the next level. So you're going to have to take that minority position.
David, on the more common, where people think they've had that conversation, which I think that's right. I think that's usually what happens. Whether or not that actually happened in someone's head or in the physical world, I'm never sure. Can you comment on that and what happens there?
yeah, that's where things are more likely to go south. Um, it depends. I mean, you need to, from a lawyer's perspective, it's very helpful to figure out if there's a misunderstanding or somebody getting greedy. Where it's the latter, where it's somebody being greedy, it will never. I mean, it will never work. It almost never works. There needs to be a separation. Um, if to be quite honest, if you're the minority founder in that situation, you should want to get out. These are not traits like greediness that, I mean, I don't want to, I don't have rose-colored glasses. There's some level, I mean, everybody has a bit of that in them, but if it's going to cause a person to be dishonest, materially dishonest, it's going to pop up in other ways. So in that situation, it's worth getting out. But if it's an honest misunderstanding or a misinterpretation, most often it's trying to steer things towards a renegotiation. Just trying to get people to understand people are working in good faith, and then it's pretty much starting from scratch with some hints of what's been discussed, and that can work. That can very much work. It's when there's hard feelings about it that cause real problems.
I think one of the things that's really important to bring up that you just made a distinction about is greed gets a negative connotation. But if you're not starting a nonprofit,
Mm-hmm.
all of us are doing something to help people, but we want to make a lot of money. But what you made the distinction is really important that I think founders should take heedance in is that if it crosses the line to make someone dishonest and cheat, so to speak, or undermine, then I would just walk away, as painful as it would be. I might fight for some minority share, but I would walk away because it'll never work.
Right. Yeah. I mean, you're right that if you're not starting a nonprofit, particularly, I mean, this is maybe it's not completely unique for the startup world, but there is, in the startup world, this this notion of in a few years going from nothing to many, many millions of dollars that for a lot of more traditional small businesses is not the kind of trajectory you're usually talking about, for all sorts of reasons, exceptions to every rule. But so in particularly the startup world, yeah, I mean, your drive could be from competitiveness and all sorts of things, but a lot of people quite naturally, that chance of the millions at the end of the rainbow is going to be a motivating factor, and that's a great motivating factor. But you're working as a startup founder, particularly if you're going to have co-founders and have investors, is you're part of a team. You're part of various types of teams, but it can't be a zero-sum game, because if it's a zero-sum game, then if two people are playing a zero-sum game on the same team, that'll never work. And if you just have a co-founder who's playing a zero-sum game against you,
yeah,
I mean, it could be successful, but you're going to be unhappy, and it probably won't be much success for you.
And there's a distinction between greed in the market, right? Greed vis-a-vis your potential acquirers or your investors, and greed within your co-founding team. I think that that kind of greed, the wanting to maximize your returns on this startup, and trying to make it, I would say that kind of greed is what's going to drive most startups.
Yeah, that's capitalism.
Should.
I mean, yeah.
But greed between your partners and your founders, that's not going to work.
Yeah, I just like that, and I appreciate you both talking about that, because I just like to make that connotation. I think in today's society, things are getting so polarized and so crazy that there's this notion that if you have a lot of money or you make a lot of money, that you're evil and it's bad, and I don't agree. I
Right.
certainly look at it through a lens of an entrepreneur who I want to solve people's problems. Having said that, I do want to make a lot of money, because that's, besides feeling fulfilled, is the scorecard. And I tried with Wells Fargo to pay our mortgage with, I've done some good things this month. Could you just take that as payment? Sort of like that movie. I don't know if you ever both saw that movie, Couples Retreat, where it's like, we pay in smiles. Like it doesn't work, man. So you gotta make money. So I appreciate you commenting on that. One thing I want to go back to as it relates, and I do want to touch on we've talked about founders, but I think it may be able to be expanded to all team members, because investors are in there with your family, you're getting married and all this. But Mital, you said something earlier that I made a note of, that I think those of us who are experienced and see it every day, I don't want to say we take it for granted. It's just, we see it every day. It's like, oh, well, you didn't sign an employment contract. You didn't sign over your IP rights. You didn't sign this stuff over in the beginning. And that causes problems. And I'll give everybody an example of which both of you will laugh at and probably say, oh, well, for somebody who has so much experience, that didn't work out well for you, which is, I did not get people to sign over the IP in the beginning. And, I'm not a lawyer. I got an MBA and I've got a lot of experience and work with lawyers and deals and all that. But when you're in the midst of starting a company, it's just like another piece of paperwork that we got to deal with. We're trying to get it like customer number 1, maybe customer number 10. And you're not worried about this, but it's vitally important, because we actually did get a patent granted in a company that I was a co-founder, or I was founder and had some co-founders in. And to get that signed afterwards took me an enormous amount of time, because now the leverage is with them.
Yep.
Because they can make an IP claim that creates, which I'll let you both talk about, an enormous, I mean, good fees for you, hard for us, on the company side to absorb. And they basically, with that one, not getting that piece of paperwork, they've locked you up in a sale. So could you both talk about or Mital, you brought it up, talk about the core documents that you like absolutely should not miss when you all are singing Kumbaya, starting this grand new venture?
There's really just two, right? There's the equity grant and the IP assignment. For the equity grant, I just want to make a PSA. Having the number of options or the percentage in the offer letter, or having it as an exhibit to your consulting agreement, is not enough. You actually have to follow through and give them the equity. So I know a lot of my clients will say, well, yeah, we promised everybody equity, it's in their offer letters, but we never actually gave the stock options. We never actually did a 409A. We never did all that. That's going to get really, really expensive. And there's going to be tax issues, because you have not actually granted that stock. You've simply promised them that stock. And especially if you've used percentages, forget it, right? Now we're 5 years later and you're going to be acquired for $50 million. That person's going to get a percentage of that, not the percentage at the time of the offer letter. So definitely get the equity done. It's not that hard. You can use Clerky. You can, there's lots of online tools you can use, or get a form from your lawyer and just use that over and over. We don't care. We're okay with that. So get the equity done, and then on the other side, make sure that the IP is locked in. That's not something you want to hold out right before the acquisition. You don't want to be chasing that person down, giving them all the leverage, as you said. Having said that, most of these things work out. There's a lot of scrambling at the end and some money wasted, a lot of money wasted, and maybe some taxes, additional taxes that have to be paid. But thankfully, it's it's rare that you have a true holdout, unless somebody's really just, just really angry and has a vendetta. Most people act rationally and can come to the table and resolve these things, but it becomes very, very expensive to do later. So get those two things done.
Well, so on the equity part, I did make that mistake too. I gave founders a percentage per se, but it was based on, I did put a line in there. And another thing for everybody listening, lawyers can be expensive, but I promise you, as much as it will pain you to pay that bill, it will save you an enormous amount of money because I wrote the document and I did put a line in there that said, you will be granted X percent at the time of the cap table at this moment, so that when a subsequent round came, they were diluted as well.
Mhm.
Will that satisfy your legal test?
In terms of what number of shares they should be getting,
yeah, so-
likely yes.
Okay.
But you didn't actually give them the stock, right? And so now you're going to give them stock after you've signed that Series A term sheet for 20 million pre-money valuation. You're not going to actually give them that stock until that Series A closes and you do a 49A, and then you have to give it to them at that higher valuation. So yes, I mean, you saved yourself in terms of how many shares is this person getting, and are they going to be diluted in this round? Sure, likely it'll be okay. Both sides agree they're going to get 100,000 shares. They'll dilute, but that 100,000 shares all of a sudden became a lot more expensive for that person. So you're going to have some unhappy employees on your hand. And you're going to have to give them some sort of bonus or something to make them happy for their tax burden.
My next question is going to come because you're going to say, wow, this guy's got a lot of scars on his back. But don't you think that you should also get an employment agreement or consulting agreement, however, if you're not a W-2, you're 1099, because I'm not going to name the firm here in Silicon Valley, but there is a true story where a person was a co-founder. They didn't get a description of their job sort of contribution. So in order to force that person out, they became the janitor. And so they said, well, we can't, they didn't have an employment agreement that said you're going to be this C-level person, or you're not going to be an engineer. Didn't say that. It said that you'll be with the company. So they just said, well, we changed your job. You're now the janitor of it, and we expect you to do the floors. And if you don't do that, then, we'll have a reason to fire you. It basically got them out. And the lesson for me in the early years was like when you join a company, have some sort of agreement about what your role is and what that's going to look like and the terms of which you could be fired. Meaning, if I steal, if I cheat or anything. What are your thoughts on that?
It's a little bit unusual because, I mean, most of these employment terms, unless it's a term employment, it's at will. So they could have fired the person at any time, unless there was some sort of acceleration for, termination without cause. In which case, maybe they wanted the person to quit and not actually have to fire them, and maybe that's why they did it that way. But usually, you can just fire anybody because that's all at will employment.
So would you encourage people not to do that? Because at will gives you a lot more leverage than actually a contract probably binds you in.
So the agreement, typically, taking a step back, the typical form, I mean, again, this is startup. Now I'm talking startup world. The typical form of IP assignment agreement usually has other terms to it. One of which is that employment is at will. It's just the standard forms that any law firm or any Clerky, Stripe Atlas, any of these platforms use will have at will employment terms. And the default, I mean, in employment law, it's a creature of state law, so it does to some extent, depending on the state you're in. But generally speaking, in the United States, the default is all employment is at will. It's a good idea. I mean, an offer letter is very commonly used, and we encourage offer letters, which would say what the position is, and some basic terms like salary and
But that's not going to save you.
but that's not going to save you. And the lack of it is not, it's very rarely is that going to become an issue down the road if you didn't have an offer letter.
Well, I appreciate
it's
you
still
com-
good to have.
I appreciate
I
you
think
commenting.
what would save you is the acceleration for termination without cause or resignation for good reason. That is might be what existed in the example that you gave, and that's what.
And that's
it might
why
turn
they
out.
wanted to stay there, and that's why they needed to
Right.
fire him, because they saved the equity effectively is what happened.
Right. And that speaks to the importance when if you're ever on either side of the table of a negotiation about acceleration for termination without cause, be very careful about what cause means. And if you're on the employee side, you want the corollary to that, which a lot of people miss, which is you get accelerated if you're terminated without cause, or if you quit for a defined set of good reasons, such as if you were hired as CFO at the company or CTO, and then you're reassigned as a janitor, or your salary is cut in half, or you're given the privilege of the mandatory opening of the Fargo, North Dakota office. I apologize if anybody is listening from Fargo, North Dakota. But
well, I appreciate you commenting, because someone listening to this is probably like, Brandon, you're asking these lawyers these crazy questions. Like, where are you pulling this out of? But these are real world experiences.
Oh yeah, these are real world experiences
that can happen. And before we go, and I'm really grateful for you both taking the time out of your busy schedules to come on here and answer these questions, because this is really important stuff. I've seen some statistics that say, and you both probably know better than I do, that maybe 65+% of startups fail, not because they didn't have a good idea, not because they ran out of money, but because of founder conflict.
Mm-hmm. Yeah, that's when you bring people together that way. It's not as surprising to us because we see so much of it.
Well, you're both very happy people and smiling, so I'm grateful that the cynicism that you probably could have does not come through. So I'm grateful for that. One last section I want to cover, just so that we've sort of covered the spectrum. How do you both feel about having it in the investor agreement that you can buy them out at a predetermined at some predetermined price, whether that's 10% above what they did, or
Buying the investor out?
Yeah, buying their investor out, just like you could just vest the investor, just like you're vesting an employee.
It's unusual. No, I've never seen an investor agree to that. I mean, you could try.
Let me ask you this. So in the Series C documents that have been going around, there's a clause in there that says that the company can, the clauses that I would use today from an experience that I had, is that with at least that Series seed on a convertible note, the company would have the option of buying out the investor at some that would need to be negotiated, but at some predetermined price.
Yeah, I see it in notes. I think I see it more often at the note level than I would in an equity round. I never see it in an equity round. The most I see in an equity round is the veto right over a sale sunsetting. If the return is at least 2x or 3x. At that point, they cannot block a sale and they won't stand in the way as long as they're doubling their money, for example. So I see that in an equity round, but I never see like a reverse redemption right for an investor.
Yeah, it's interesting because the typical, not that it's common, but what you end up seeing is kind of, Brandon, the reverse of what you say, which is a redemption right, where the investor can force the company to buy back their shares after a certain period of time. But I'm trying to think of a deal that I've seen where the company can buy back the investor shares. It's hard because most more often than not, by a huge margin, the investors have more leverage at the moment when these deals are getting negotiated. It's just, kind of the way things are. And
I see it at the note, the
at
convertible.
the note level, sure, yeah, that I've seen that that happen. And it could be very valuable. I mean, later on, investors don't tend to care about how much. I mean, it's not. Later on, investors don't care that some seed investor put in $1 million and hasn't put in any money since then. Really, they don't really care about that in the way they care about early on employees who are no longer there. But early investors can also be a pain. Particularly, they can be a pain if you as a founder sign side letters with them that give them all sorts of rights that you can't get rid of. So that's another PSA. Be careful about what you sign with your investors, particularly side letters. Anything that's in a side letter should get extra special scrutiny.
I think that's good advice, and I know it's super hard as a entrepreneur to not do that, because you want that money so bad, because you believe that the money is going to make your idea come to fruition. I will tell you that is not necessarily true. And sometimes not having the money is better, candidly, because you become more creative.
Right.
But I know you want that money, and I appreciate you making that distinction as it relates to the note. I did have a note, and I didn't have that clause in there. And it was very clear that the relationship, and I'm sure you've both seen this over and over, where everybody's in love in the beginning and everybody looks hot. And then, 6 months later, you're like, you're really not as hot as I thought. And then you want to break up. And in this case, or I shouldn't say our company wanted to buy back the investor's money, and the investor wanted to stay in, even though we weren't getting along, because they saw that they probably make some money. And it was excruciating. It was really, 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 really hard. So I encourage, it's really hard to, I'm saying really hard a lot. It's really hard to talk to you both, because all of us here, you have to wear both hats. So you hate to say to entrepreneurs, hey, always put in that clause, you can get bought back. But as an entrepreneur hat, I'd be like, always put in that clause, because that's a good cause for you.
I also think there's a distinction to be made between investors when you're dealing with them individually, and investors when they're part of a group, right? So if you have a troublesome Series A preferred stockholder, they're not going to cause much trouble for you, because most of the decisions are made by majority. And so as long as the majority group can you can deal with them and try to get their signatures on things, then one troublesome, Series A preferred stockholder is not going to be a problem. But if you're going to have individual relationships at the seed level with a note holder, then it's probably wise to have a way to get out of it.
Well, that was a very good politically correct answer. And I actually think beyond just politically correct, the right answer, Mital. So thank you for that. From both of you, maybe individually or collectively, what 3 tips, high percentage tips, would you give a group of people who are founding a company out there, or thinking about founding a company, to do before they get on with creating this greatest new thing?
I would say tip number 1 is make sure people are going into it with open eyes, right? As we were talking earlier, sometimes you can get a personality in there that's really just mistrusting or greedy, for example, and just does not, at every step of the way, it's like pulling teeth, trying to get them to see that we're all working towards this, or we're, no one's trying to cheat you, no one's trying to push you out. Like, you kind of have to have faith in everybody. So, we talked a lot about, don't make sure you get your paperwork signed, make sure this gets done, otherwise there's all kinds of pitfalls. But majority of teams are working together, right? Most of it usually works out. So you don't want to be on the other side of it, where you're so suspicious all the time that someone's out to screw you, and that can also kind of cause delay and and hold things back. So make sure the team that you're going into it with, that everyone's understands that this is risky. Look, we could lose money, it might not work out, but you kind of have to have a level of faith and trust in each other. Same thing with your early investors, right? You can get some high net worth individual who can float you 100K or 200K, but if they're not in this ecosystem and aren't aware of the risks, they might approach it differently, and they might get, again, suspicious along the way and ask to see financials and ask to see how did that 200K get spent, and want it back 6 months from now, or want updates in a way that startups can't provide. So either stick with people who've done this and who kind of know what's standard, or if you're going to get some, gallery owner or some doctor who just has money laying around investing in you, make sure they understand that this isn't like any other investment, that this is a startup, and there's going to be risk, and then they might not get a lot of information for a while, and they just have to be okay with that level of risk.
It's somewhat related to that, but don't put off hard discussions and hard decisions. And that does relate to the paperwork equity split thing. Don't put those things off till later. Those are hard discussions, and they're decisions that are important to make and should be made at the beginning, because they're cheaper to make at the beginning, but also because being on the same page from day one will save people a lot of time and heartache. But that just will travel with you through your life of being an entrepreneur, particularly when you have a team of co-founders, or really when you're working with people in any capacity. Decisions don't get easier typically over time. It doesn't get easier to discuss things or document things or make a decision on things later. I mean, in some situations you need more information, but if you're just putting something off because you think it'll be hard to discuss X with your co-founders, that's just going to lead to problems later.
And then I would say also educate yourself, right? There's a lot of smart people out there. I don't understand the technology. I don't know what the founders themselves are doing, but they know what they're doing. They're smart. I know they're smart, but sometimes we have a class of founders who are very smart, and then they're really trying to make a go of it with this company, but they're completely ignoring one side, the legal side of it, for example. You don't necessarily need to get into all the details, but understand, right? Understand the lingo, understand what it is that you're actually doing and signing on to, so that it's not just, don't ignore it. And when your advisors and your lawyers and they're trying to tell you something, that you can actually hear them. Because if you don't understand the lingo at this point, then you're going to be in trouble. And there's really no excuse, because there are a lot of resources out there to educate founders. So yeah, I would say do your homework.
Well, I think those were great. And before we go, how would someone listening to this work with your firm and both of you? Is there a process? Do you apply? Do they find you on the web? Can you tell our listeners how they do that?
Yeah, most people just find us on the web. Most of our meetings are, on Zoom, or most of the work is done over email. We do have an office in Cupertino, so people are welcome to schedule in-person meetings when we're back there. But for now, yeah, we have clients all over the world, really, and obviously with a concentration here in the Bay Area. But yeah, just find us on online, grellas.com.
Can you spell that for our listeners?
Sure, GRELLAS.
.com.
Yeah, .com.
And you handle all aspects of early stage companies, intellectual property, corporate governance, formation of the company, I don't know what else
M&A.
M&A, VC financing.
Yeah.
The whole 9 yards.
The whole 9 yards. So
again, one more time, your URL.
Sure, it's www.grellas.com. That's GRELLAS.
Well, thank you both for taking the time out of your day to join us, and really appreciate all the great advice.
Great.
Thank you.
Thank you for having us.
Great.